We've got some fresh new young talent doing some things that I know you haven't heard before.
1, 2, 3, listen.
Welcome to Finances, your home for all things financial, investment, money and lifestyle. Hosted and curated by the very talented team of certified financial planners, Burke Britton Financial Partners. Welcome to the Finances Podcast. We have, our guest today is Daniela Pavlovic. Daniela is a principal in Harwood Andrews, wills and estate law practice. You might be better served to give us your bio, Daniela, because you looked at one on the website and you said it was a bit out of date. So let's welcome to the podcast first of all.
Thank you. Thanks for having me.
And you said that this is your first podcast?
Yes.
Yeah. You nervous?
I am, actually.
Isn't it weird?
Yeah.
You talk for a living, yet we put headphones on and a microphone in front of you, and I suppose we've got a camera as well. Yeah, but that's okay. Let's talk a little bit about you before we talk about estate planning. For those out there listening that don't know who you are, tell us a little bit about yourself. Let's maybe go as far back as you want to go. Where were you born? Where did you grow up? And how did you get into the legal fraternity?
Okay, so I was actually born in Serbia, but my parents immigrated to Australia when I was a baby. So I was raised in Geelong, to primary school, high school, university in Geelong. I completed a commerce and law degree at Deakin University and then started my graduate role at Harwood Andrews. So I've been there from the beginning. So I started as an article clerk in 2007, and over the years I've sort of moved my way up the firm, and now I'm one of the owners. I'm a principal and a principal in the wills and estates team. So I've worked in that practice area my whole career. It's really surprisingly interesting practice area. It's actually very diverse, very people-oriented. So you meet a lot of people, you hear a lot of different stories. You get to know your clients on a fairly intimate level. You know about their lives, about their families, their financial circumstances, their concerns, their fears about the future, all of those things. So it is interesting, and every family is different. You hear lots of different stories. Some are wild, get a few eye-opening situations, but yeah, every day it's something different.
Is that what you always wanted to do? Like, is that the area that you saw yourself getting into, or not really, just fell into that?
No, I didn't. And it's actually not usually a practice area that law students really think about. I think they tend to think about what they see on TV and, courtroom dramas and working in the big city firms, corporate jobs and stuff like that. And so when I started my articles, I did a rotation in a few different practice areas, and I ended up in wills and estates, and I loved it. So now I'm really quite encouraging of younger lawyers to give it a go, because it is actually really interesting work and challenging work, and you're just constantly learning new things.
That was probably the quickest bio from I was born in Serbia to your current role. I'm sure there's a story there. There's a story there somewhere. I'm not sure whether you want to talk to. How old were you when you actually came over from Serbia to Australia?
Oh, I was just a baby.
Okay, so
14 months old.
Oh wow.
Yeah.
Okay, yeah.
Yeah. My mother's family actually had come to Australia in the 70s. Yeah. So my mum came here in her early teens, and then my father came when he was about 20, and he never planned to live here. He just came for a holiday, sort of a working holiday. He met my mother and convinced her to move back to Serbia because he never planned to be here.
Okay.
So they got married and returned overseas. Lived overseas for a few years. I was born, and then my mum dragged him back here. So, which his mum was never really happy about, but it was a good move.
Have you been back to Serbia?
I have a few times. All my extended family still lives overseas, mostly in Serbia. I've got a first cousin who lives in Switzerland. My mother's family's a bit more spread around. They're all different parts of Europe and a few in sort of America and Canada.
Yeah. Did your birth in Serbia pre or post date the war in Serbia?
Pre,
yeah. Shows my knowledge of that. So what year was the wartime in Serbia?
I think it was the sort of early 90s.
Okay, yeah. Well, there you go. I'm pretty sure that you were born before the 90s, without aging it too much, Daniela. So when you did come to Geelong, whereabouts did you grow up? Like locally, whereabouts, where was your stomping ground in Geelong?
Yeah, so my family was based out in Corio. I went to Norlane West Primary School. Yeah. It was a pretty ethnically diverse school and upbringing.
You probably, my mother-in-law taught out at Norlane.
Norlane West?
Yeah, Norlane West. I might have to correct that. I'll check with Margie. Margaret Smith was her name. Crazy Dutch lady. But Margaret and Malcolm Curry's, my wife's parents, both teachers out that way as well. Yeah,
so, as I said, a pretty ethnically diverse school. And then I went to Sacred Heart College for my high school, and I did fairly well. And I wasn't necessarily passionate about moving into the law, but it was one of those things where I got enough points and it was an option for me. And
what was your TER, Daniela?
95, something like that.
We're out of our league here.
Maybe add ours together.
I wasn't necessarily aspiring to be a lawyer at that time. It was an opportunity and I thought, why not?
Did you have an idea? Did you have to Ben's point, did you have an idea of what you actually wanted to do?
Well, I think the longer I went through, the further I went into my law degree, the more I thought that was the path that I was taking, that I would end up being a lawyer at the end of that.
Funny that you're halfway through your law degree when you worked out that you wanted to be a lawyer.
Yeah. I think there's a big expectation on young people to work out what their career path will be very early in life. Law degree is good though. It gives you lots of opportunities. You don't have to work as a lawyer. You don't have to work as a lawyer in a private practice. You can work in government roles.
You say you did commerce law as well, so it's even more diverse.
So I did a commerce degree too with a major in management.
Yeah.
But I think probably in hindsight I would have done an arts degree instead of a commerce degree.
Yeah.
When I chose my degree, I thought that was a more sort of...
It's just like the pigeonhole degree though, if you get a high
I thought it was sort of a more sensible kind of degree, but I think I would have probably enjoyed an arts degree more.
Yeah.
I think you can pursue different interests.
Yeah. And when you came to be working in a firm, so you left uni, so you graduated from Deakin University here in Geelong, and where was your first position after that?
Harwood Andrews.
It was at Harwood Andrews straight away.
Harwood Andrews, yeah. And I'm not sure if I should probably disclose this on a podcast, but I didn't actually like it when I started.
It's all right. Enough water's gone under the bridge now. So,
edit that out. 55 seconds.
Look, when I started, I felt like the law wasn't what it was, cracked up to be. I pretty much thought I'll give this a year and then I'll be done and I'll think about doing something else.
What brought you to that conclusion?
I'm not sure. I think the different practice areas that I'd tested out, I just didn't feel like it was me.
So what were they? So you said you did the rounds in other practice areas. Which areas didn't you like?
I don't know if I should say that.
All right, we can keep that one secret.
But I think the sort of, I spent a bit of time in business law and corporate, a bit of time in litigation. I actually didn't mind litigation. And then I went into wills and estates and I really found my place and my people. Yeah. So I had a great team. I had a really great mentor. I loved the work. I just found it so interesting and I've stayed there since.
It's a bit more personable compared to the some of those business areas.
Yeah, it's very people-oriented, so that really suited me.
Yeah, you're definitely a people person, Daniela, that's for sure. I know just from all of our clients that have dealings with you, you're very well received. So I think it's certainly in your wheelhouse. You mentioned you found your people. Was there anything about estate planning itself that really appealed to you? Obviously, you get a great team. You found the right people in there at the practice to work with. What is it about estate planning and helping people that probably really resonated with you?
I think that you really get to know your clients on a personal level. They're really talking to you about very important things to them. They look to you for guidance, for support, for advice. Sometimes they ask you for advice. It's not legal advice. What would you do if you were me? That sort of stuff. Yep. They can disclose some very private information to you and they trust you with that. And it's really satisfying when people say to you at the end that you really helped them through a difficult process. So I don't just do the estate planning aspect, we do estate administration work as well. So when somebody dies, we assist the executors to complete the administration of the estate. They're obviously working with us in a really difficult time in their lives. Quite often they've lost a partner, parent, a child, really difficult circumstances. So you've got that emotional overlay to the work that you're doing as well. People can be quite overwhelmed by the process, by the amount of paperwork. So just helping people through that is really just satisfying to me.
So I thought maybe we'd touch on sort of some of the basics without trying to get too bogged down in the detail of estate planning. Obviously, it's a very complex area. It can be a very complex area. Maybe let's talk about what estate planning actually is, and then some of the core tenets or the core foundations of estate planning and having a estate plan in place. And then maybe we can touch on sort of some, I suppose, tips and traps around making sure that your estate is in good shape.
Yeah, so at the very basic level, estate planning is making a will, and that is preparing for what happens when you die. And a will can be anything from a very basic document to a really complex will that sets up trusts and things like that. So a will serves two main purposes. One is to appoint an executor or executors of your estate. The executorial role is an administrative one. The job of the executor is to arrange a funeral, to identify what all your estate assets are, identify what all your liabilities are and your debts, and then go through the legal process of administering your estate. So calling in and collecting your assets, selling assets, transferring assets, and then distributing your estate to the beneficiary. So the first job of your will is to appoint that legal personal representative of your estate.
It's kind of an important nomination, isn't it?
Yeah, and if you've got minor beneficiaries, the executor also become the trustee, and their job is to look after, invest and manage a child's inheritance until they've reached 18 or 21 years or whatever age you've nominated for them to take their inheritance outright. So it's a really important job. The executors have a huge amount of power and discretion in terms of how they administer your estate and how they deal with your estate during its administration. So it's a really critical appointment. And then the second part of the will is to identify who the beneficiaries are, and that's who's actually going to receive your assets when you die. So obviously family members, spouse, children, friends, charities, nieces, nephews, anyone that you want to receive your assets. So you have the opportunity in your will to nominate specific bequests or gifts if you have any personal or sentimental items that you want anybody to have, or if you want to make a bequest to a charity, for example, of a nominated amount, and then you can also devise sort of what's left over in percentages or proportions between nominated beneficiaries.
We've talked a lot about in some of our previous podcasts about how preparing a will tends to be something that people kind of put to the too hard basket. It's like, it's too hard to talk about, I'm not wanting to think about. And like most things, it tends to not be a problem until it's a problem.
That's
Obviously,
right.
the result of not having a will generally doesn't come to fruition until you've passed away and your family's dealing with the fact that you've got no will. Maybe I think I'm probably jumping to now dealing with the estate administration, but what are some of the issues and risks of people passing without a will in place?
Yeah, so there's a risk of dying without a will, and when you die without a will, you've got an intestacy. So the law then sets out how your estate is to be administered, and those intestacy provisions might provide for a distribution of your estate in a manner that you don't intend or you wouldn't want. The other issue is that you haven't appointed an executor, so somebody who has an entitlement in your estate has to apply to the court to be appointed as an administrator of your estate because you haven't appointed an executor yourself. So, yeah, one issue is not having a will and having a distribution of assets that you don't want or didn't intend. The other issue is also out-of-date wills. So people make wills and their circumstances change. They might separate from a spouse and not divorce, and they've got a will which appoints their spouse's executor and gives them the whole estate. They might have had a falling out with people who were nominated. There might be other reasons why someone you've appointed as your executor isn't appropriate to act in that role anymore.
Often we've come across they're not around anymore. They've passed away.
They've died, they've lost capacity. There might be some other issues in the background in terms of that person's ability to do their job properly.
Yep.
So it's important not only to make a will but to review it from time to time.
Yep.
We would generally recommend that you review every 5 years or so. And review doesn't mean that you have to make a new document constantly, but just have a look at what you've got in place, check whether it's still current, whether people that you've nominated in various roles are still appropriate to act in those roles, whether the will still divides your estate how you want it to be divided up, so all of those sorts of things.
Just a quick one on that. So divorce does that void it or not?
Yeah, so divorce does revoke your will
Yep.
to the extent of the appointment of your spouse as executor and any gift to your spouse, but separation doesn't.
Yeah.
So there's a lag between a separation and a divorce too, because you can't divorce your spouse until you've been separated for 12 months. So if you do separate, you need to update your will because your spouse is your spouse until you divorce them. That's also important for superannuation purposes too, because your spouse can make a claim for your superannuation benefits. So probably a good segue into super.
It is. Well, maybe that's a good segue into estate versus non-estate assets. So this is something that I think there is sort of broad, not confusion, but people aren't generally aware of when we start to talk about estate planning. What are the assets that actually make up your estate? What doesn't form part of your estate? And how can you actually address those assets that technically sit outside of your estate with some good estate planning?
Yeah, that's an excellent question, Jay, because your will deals with your personal assets, and that sounds like a really obvious statement, but it's not. So the first part or point, I suppose, of dealing with preparing a will is working out what the estate assets are. So your estate assets are assets that you hold in your personal name. So bank accounts, shares, investments, property in your sole name. When you die, your will governs the distribution of those assets. There's other ways that you can hold assets or control assets too. So if you hold assets jointly with anybody, this is usually spouses or partners, there's a rule of survivorship that applies to jointly held assets. So on the death of one person, the survivor automatically acquires that asset. The deceased person's interest in that asset is extinguished and doesn't form part of their estate, and therefore isn't governed by the terms of their will. So if you co-own property with somebody as joint proprietors and you make a provision in your will that you want your share in the property to pass to someone other than your co-owner, then that is ineffective because you don't have the ability to deal with your interest in a joint asset in that way.
That part we probably see more and more when you got second marriages, or I've even have a few clients where they actually share homes with other people who they're not their partner because they couldn't afford to buy a property. They might have retired and living with a sibling or someone, but they don't have that purchase correct, that their separate entities miss out.
Yeah, that's right. So people overlook that entirely when they purchase property, that there are two different ways that you can register ownership when more than one person owns property. So joint proprietors or joint tenants is the default, and that's where you have that rule of survivorship. So if you've got siblings or friends co-owning property, they probably don't intend for their share of the property to pass to the surviving owner. Even sometimes in a second marriage or second relationship, there's an intention to sort of keep separate shares in property. So that's a problem if you're co-owning property as joint tenants or joint proprietors. You can also register ownership as tenants in common, and that's in either equal shares or unequal shares. And if you own property as tenants in common, then your share in the property is your asset and is governed by your will on your death. So that's a really important consideration. So joint assets sort of out of the estate. The other one is superannuation. So the distribution of superannuation benefits on death is governed by superannuation laws and the rules of your fund. And if you're a member of a super fund, you need to give separate directions to the trustee of that fund about how your superannuation benefits will be paid out on death. And you do that by making a binding death benefit nomination, which gives a binding direction to the trustee of your fund about how to distribute your benefits. If you don't have a binding death benefit nomination, the trustee has a discretion to determine how to pay your benefits out between any of your dependents or to your estate. So superannuation can form part of the estate, but only if it's first paid from the fund to the estate. So that's probably a
point of confusion for a lot of people, is that it can go via there, but if it's not told to go there, it won't go there.
That's right. And look, there's sometimes we deliberately keep the superannuation out of the estate. Usually, if the person's going to be survived by a spouse, we'll just direct the superannuation out to the spouse. Sometimes we bring it into the estate deliberately because we're setting up testamentary trust, for example, or superannuation proceeds trust, and we want to bring that asset into that estate asset pool so it can flow through to those trusts that are established by the will. So it just depends on the client's circumstances. Another circumstance where we deliberately want to keep super out is if we're anticipating a potential dispute in respect of the estate. So if we think somebody's going to make a claim against the estate or could potentially make a claim, we don't want to bring the superannuation in and expose that asset to a dispute.
That might be worth just diving into a little bit around the potential for claim? Because when we talk to clients initially, even if they have a basic will or they've got nominations on their superannuation, sometimes they're of the opinion that that's set in stone, that is actually how it will, the outcome, that is what the outcome will be. From an estate planning point of view, what are the rules and what do you see in terms of people actually challenging? So I think has it been a recent change in challenging of estates or?
No, there was a change a few years ago which introduced eligibility criteria for claimants. So a claim can only be made against an estate by certain persons who fall within eligible categories. Before that, any person could make a claim against a will, and there was a view that it was sort of too loose in its application. So you'd have claims by neighbours, carers, nieces, nephews, those sorts of claims, and there was a view that shouldn't happen. So the eligibility criteria has been brought in to really narrow the class of persons who can make a claim against an estate. The good news in terms of claims is with superannuation, if you have a valid and current binding death benefit nomination in place, the trustee must pay your benefit out in accordance with that nomination. So it's very difficult to challenge a valid death benefit nomination.
It's good if it's to the right person.
To the right person, yeah.
I was just about to say, one of the, obviously, trustee discretion can be a positive or it can be a negative.
Yeah.
And from a super point of view, one of the reasons it's so important to make sure that your beneficiary nomination is up to date is if you've left a binding nomination to someone that you don't want to get it, then unfortunately it opens up a can of worms there for potentially going to the wrong person.
Yeah, that's right. Another pitfall with binding death benefit nominations is that people nominate beneficiaries that aren't eligible to receive superannuation. Sure. So unlike your will, where you can give your estate to anybody or any organisation that you want, with superannuation you can only nominate a dependent. A dependent is a spouse or a child or a person who's in an interdependency relationship with you, or you can nominate your estate. So if you nominate someone who isn't within that category of dependents, then your nomination's invalid. So we do often see people nominating siblings, friends,
their parents.
Their parents. Young people nominate their parents.
Young people, yeah.
And those are generally invalid nominations, so they would fail. If you have a single person who doesn't have any dependents, they should be nominating their estate to receive their superannuation benefits. In
that event, when someone is nominating their estate but maybe they haven't got the wills in place, what are you encouraging them to do? Get a basic will?
Basic will. Yep. Look, ideally, you would have your client make a will and a binding death benefit nomination. They need to do both. They're really two cogs that need to work together.
Sure.
Yeah. I think you asked me actually also about estate disputes. Sorry, I forgot the first part of the question.
I forgot what the question was as well.
About people being able to make a claim. So, yes, as a will maker, you've got testamentary freedom, and that's the freedom to make your will how you choose. But that freedom is, let's say, curtailed or limited by other provisions in the law, which allow a person who believes that you had a moral responsibility to provide for them, to make a claim against your estate if they can establish that you failed to make adequate provision for their maintenance and support.
So how often do you see people making a claim on an estate? Separate to what the provision of the will, how often do you see it? What percentage are you seeing people?
It's actually not that common.
Okay.
There are a lot of disputes in families when people die. It's a highly emotional time, so people do fight about all sorts of different things, but there's not a huge amount of family provision claims, because it's not just the case that you can make a claim because you're unhappy with someone's will, because you thought they should have done something different or they should have left you more. There's still that legal test of proving that they had some moral obligation to provide for you and they failed to meet that obligation. So it's a much more difficult legal test than maybe it appears at first instance. So,
are there things that, I think the question of, are there things that you can do in the establishment of a will that goes some way to helping avoid the potential for a claim? Or
the best thing to do is really assess the risk and consider the sort of typical scenarios where we see the most disputes. So an obvious one is where there's been a falling out or an estrangement and a person cuts out a child, for example, out of their will. And you'd say, well, that's probably a high risk there. That child would make some claim against your estate. Seems to be a fairly obvious scenario. But actually another scenario is where there's a relationship that could potentially be a de facto relationship. So we see quite a lot of disputes about whether a romantic relationship is or isn't a de facto relationship, because a de facto relationship is like having a spouse. It's akin to being a person's spouse. And so you've failed to make provision for a de facto, that person could make a claim against your estate. And another sort of type of scenario where we commonly see disputes is in blended families, because that situation is tricky because you have to balance your obligation to provide for your spouse against your obligation to provide for your children. Quite often the spouses each have a child or children from a prior relationship. They might even have a child or children together. And so that blended family does make estate planning very tricky.
Real simple, again, it's not simple, but if, say, a couple have 3 kids and there's one that's estranged, there was always this, probably a myth that, you leave $1 to that one that stops them challenging. What do you see most people do, or what's the balance of risk there? Is it leaving something, or how does that end up falling to protect?
Yeah, so that is a myth.
Yeah.
There's no magic number that stops
there used
the
to
claim
be
being made.
People still come in and say, I leave them $1 and go, I think you meant to speak to someone about that.
We've just myth busted that. So.
Yeah, so there's nothing you can actually do to stop somebody making a claim against your estate. There's no legal brick walls we can put up during your lifetime. That risk exists. There sometimes are strategies to reduce the risk of claims, or to reduce the impact of claims more so than the risk of the claim. So people can do things like ensuring that superannuation benefits don't come into the estate. They can do things like owning property jointly with someone so that their interest passes automatically to the survivor. You can make gifts during your lifetime, and assuming you're competent when you make that gift, it can't be clawed back. In Victoria, we don't have these notional estate provisions that they have in other states where you can claw assets back. So there's different things you could do. But most people are not in a position where they can make substantial gifts of their property during their lifetime to avoid a claim.
Yep.
Our job is to advise the client that it's a risk, and different people have different appetites for risk. So some people are really frightened by the prospect of a claim being made against their estate and their family being embroiled in a dispute in the Supreme Court after they die. And so they, make some provision for a child that they don't really want to make provision for, just to try and reduce that risk, because they think, well, if I give them something, that might be enough to stop them asking for more. Other people take the view, well, I'm going to make my will how I want to make it, and if the person thinks that they should have been provided for, they can make a claim after I die and my executors will sort it out. So different people have a different approach.
Where do you see it with that, Daniela, in terms of providing direction around which of those ends of the spectrum is where people should likely sit with their planning?
Well, that's really their own choice. My view personally, it's not legal advice, it's my own personal view, is that you should make your will how you want to make it. And there's a mechanism in the law to deal with a claim if it's made after you die. Your executors would become the defendants in any proceeding. Their job is to defend the claim and uphold your will. That might result in a settlement being reached with the claimant. If it can't be resolved, then a judge will decide whether you failed in your obligation to provide for that person. If you did, to what extent they should be provided for. But lots of people don't like the idea of that, the legal proceedings after they die.
Yeah. We've talked about the need for basic wills. What are some of the other things that increase the complexity of a will? So I'm thinking, we've talked about blended family situations. What about where people have significant other assets through other entities, so companies, trusts, etc.? How do you deal with those assets held not personally, but maybe held through trusts or directorships or trustee responsibilities that people have? How do you deal with that from an estate planning point of view?
Yeah, well, the first part is actually having your client understand that they don't own those assets. So this is another asset that falls outside of your estate. When we spoke about what estate assets are earlier and what's not in the estate. Trust assets are not in your estate. So lots of people will have family trusts that they establish during their lifetimes. Maybe the trust controls a business or it invests money. And those trusts are separate legal entities. The trust assets belong to the trust and not the individuals. So the individuals might control the trust by virtue of being a trustee of the family trust or a director of a company which is the trustee of the family trust, so they control the assets but they don't own them. The consequence of that from an estate planning perspective is that you can't give away trust assets in your will because you don't own them. So we need to look at the trust separately. We need to ensure that that cog works with the other cogs as well to be able to give, a completed plan for the client. Every trust will have a trust deed. That's the rule book for the trust, basically. The trust deed sets out who controls the trust, what the mechanisms are for the succession of that control. So say if the trustees die or they lose capacity, who the beneficiaries are, what the trustees can and can't do. No one ever reads the trust deed. Their accountants usually hold it, but it exists. And so if there's a family trust, whilst you can't give away the trust assets in your will, if you control the trust, you can give away the control of the trust. So we need to look at the trust deed. We need to look at what the default provisions are that are already in the deed and what's in there might be adequate in terms of who controls the trust after the client. And if they're not adequate, then we can update, like do a deed of appointment where the client can appoint someone to replace them if they can't control the trust anymore.
Every time we start to talk about these concepts, it's so hard not to dive into the complexity of it. Like as soon as we start to talk about companies and trusts and we start to then go talk about appointors, just kind of, for most people, it blows their mind.
Yeah.
But the complexity of it, you can see why people sort of shy away from estate planning, thinking that it's kind of too hard. And I suppose the thing that we want to encourage people to do is recognise that there is complexity here, but we're much better off actually going and seeking some advice and direction around these to get, like you said, the cogs in the right place, working together. We've got these parts of people's financial circumstances, the companies, the trusts, the superannuation, their properties. It can be complex, but you can address a lot of it by actually just seeking advice and going to speak to people that actually have a handle on it.
Yeah, and look, if you're in my office now and there'd be a whiteboard that I would go up to and I would draw 3 or 4 columns, depending on what you've got, and I would show you visually what sits in each column. People can really see it much clearer when they can see it sort of in a diagram. So we would really list out, okay, what's held jointly? That goes in column 1. What's held personally by you that's dealt with via your will? Column 2. Superannuation, column 3. Family trust, column 4. And then they can really see a visual representation of what sits in each bucket and where we want to direct each of those buckets in the event that you die. So it is complex, but it's not necessarily complicated once a client understands where each asset pool sits in each bucket and what mechanisms need to be in place to deal with each of those.
What are some, we've talked about a couple of them, but what are some of the, you probably see them after the fact. Like if someone's seeing you, that you've probably addressed most of the nuts and bolts of their circumstances, but what are the common mistakes, common issues that you see sort of after the fact with people's estate plans? What are the most common, what's kind of the top 3 most common mistakes people make with their estate planning?
One, I think, is just not having up-to-date documents where they've made documents 10 years ago, 20 years ago, and circumstances have really substantially changed and they haven't updated their documents.
So what would be considered a significant change in circumstances that would warrant? Because we see a lot of people with their very basic wills, the mum and dad wills with everything of yours goes to me. In the absence of us both, it all goes in equal shares to the kids, and they might have their principal place of residence or incorrect that may have been updated, but nothing else has really changed. What are the things that really lead us to needing to update a will?
So one of the common ones, which is that people will make wills when their children are young, and they'll appoint someone other than their children to be executors. So usually siblings or parents, and their children have grown up in the interim and are adults themselves. And really, in those circumstances, the will should have been updated to just appoint the children as executors instead of appointing, other family members. There's no need for anyone else to oversee that at that point. So that's sort of a pretty easy one to bring up to date. The other circumstance is obviously separation, where people don't update their documents after they separate from their spouse. The third trap I think that we find is that people try and deal with assets that they can't deal with in their wills. So again, they've made an assumption that their superannuation is in their estate, or that assets that are held, turn out to be held by family trusts and not them personally, are in their estate. So the will tries to do things that it can't do. So, there are a few sort of common pitfalls and mistakes that we see.
We talked before, and this might be not a complete segue, but I think you said testamentary trust earlier, that some wills will have the provision for a testamentary trust. It's something we discuss a bit with our clients. Can you talk to what testamentary trusts are and how they can be, or at least provision for, can be included as a part of people's estate plan?
Yeah, so there's different ways you can structure your will. Most people have what we'd call a standard or basic will that just divides their estate up or distributes it to nominated beneficiaries, and those beneficiaries receive their inheritance outright. There's another type of will where you can set up a trust or trusts in your will, and they're called testamentary trusts because they're created pursuant to a testamentary instrument, which is a will. But essentially they're a family trust. So I mentioned family trusts before, and you're basically setting up a family trust in a will. The distinction is that the trust is only created on death. It doesn't come into existence until after you die. So testamentary trusts can be useful and appropriate in some circumstances, and they do provide a level of asset protection for the family. A testamentary trust is a way that family assets or family wealth can be passed down to the next generation and hopefully generations after for the benefit of the whole family group rather than the individuals. So with a family trust or a testamentary trust, the beneficiaries are a wide group of people. So it's not just your child, it will be your child, your grandchildren, great-grandchildren, their spouse, everyone's spouses, related entities, cousins, nieces, nephews, sort of a whole wide pool of people. But none of those beneficiaries have any ownership interest or entitlement in the trust assets. They're just a pool of people who can benefit from the trust. With a testamentary trust, you have to appoint trustees, and the trustees have a custodial role. Their job is to look after, invest and manage the trust assets for the benefit of the beneficiaries. The trustees also have this discretionary power to determine how the income and capital from the trust is administered and distributed amongst any one or more of the beneficiaries. So the trustee role is the critical one because that's the decision maker.
So why would people want to have a testamentary trust? I'm thinking, practically speaking, let's say we've got an example of a basic will, $10 million worth of assets, someone with 5 children, and those assets, basic will, they get divided up in 5 equal shares with the children. Those assets are then the children's assets, as opposed to the testamentary trust where that $10 million is held on trust for the benefit of potentially those children and maybe the others that you spoke about. Why would you do that? Like, why would we have provision for a testamentary trust?
So there's 2 main reasons. One is for asset protection purposes. So with a testamentary trust, the individual beneficiaries don't own the assets of the trust. So if any one of those 5 children is what we call an at-risk person, say they're in a shaky or rocky relationship, or they are in business and there's some business risks associated with, or financial risks associated with that business, or they have some personal insolvency issues, any assets that they inherit personally are exposed to those personal risks. So by holding the assets in a testamentary trust rather than distributing them to the individual, there's a level of asset protection in terms of that individual who's at risk because the trust assets don't technically belong to them. It's not an absolute protection, but it's the best sort of way that you can try and preserve or look after family wealth for the benefit of the whole family. The other advantage of a testamentary trust is the flexibility that it provides. It is established for the benefit of the family, and so the trustees can determine how they manage that trust fund and how they distribute income and capital and who they give it to from time to time, so it can benefit more than one generation. There's also some income tax benefits that flow from that structure. Because the assets are held by the trust, any income that's generated is income of the trust, and the trustees determine how to split or allocate that income amongst the beneficiaries. So each of the beneficiaries receives a share of income if the trustee is determined to give them some income, and then those beneficiaries are taxed at their own marginal rates on their share of the trust income, obviously depending on what their other income is from other sources too.
Do you feel as though you mentioned a couple of reasons for potentially establishing or including the testamentary trust. Is there a threshold that you see in terms of the quantum of assets that someone might have in their estate where it's less than which it would maybe not be viable and above which it maybe is more viable?
There's a bit of debate about that. I don't have a specific number. I think it's more based on the risk profile of the beneficiaries as opposed to the size of the estate. We would normally say if it's $10 million, it's probably a no-brainer to have a real consideration of whether that should be done. I think it's probably sensible in those circumstances. But I'd probably say, $1 million plus, you definitely consider whether it's appropriate for the client's circumstances.
You put that provision in there to have the testamentary trust doesn't mean that the executor doesn't have to go down that path. Is that right? Or you could elect to say that you assume there was going to be a scale of assets upon death, but for some reason there's not, and there ends up being $100,000 to distribute, but it's got the testamentary trust provision. It doesn't have to be used. How does that? What happens there?
The trust can exist for up to 80 years after the person dies. So ideally, it can benefit multiple generations, but the trustees have a power to vest or wind up the trust early. So,
but is your question, Ben, does the executor have the power to not establish the trust?
No, if the will provides for the trust to be established, then it needs to be established.
So they could establish it, but they could wind it up immediately. Because they could go, look, there's $50,000 in there, the administration costs outweigh the benefit.
We can also draft options where, the primary beneficiaries can elect whether to have a testamentary trust established or receive their inheritance directly. Yep. Usually we just provide for the trust to be established and then leave it to the trustees
I suppose
to determine at the time.
It's not something that's locked in. It's going to happen initially, but there's still that discretion to wind it up. It's not something that, if that's in there, it's there for 80 years.
Yeah. So I've got a few current matters where the will sets up multiple testamentary trusts, basically one for each child and their family. And we've had circumstances where, one of the three children says, I don't really want the testamentary trust. I don't see any benefit, or I've got other plans with that money, or whatever the circumstances are. And that trust is wound up virtually immediately, and then the other two children continue to administer their trust. One of them might administer it for 50 years and the other one might run it down to 0 in 5 and wind it up. But
so I suppose that having it in there, if you don't have the provision in there to start with, you can't have it.
You can't opt in.
If you've got it in there, then you can opt out later on.
That's right. Yeah, that's right. That's the benefit of having that provision in the will for the establishment of the trust, is they can wind up the trust. But if you've just got a standard will that doesn't provide for the trust to be established, they can't decide to do it after.
Yep.
I'm mindful of we've been going for now, nearly an hour, would you believe
really?
that? Yeah. So, like a lot of our conversations, once we open the floodgate, it's really easy to continue to talk because there's so many aspects to this. Maybe if we close out, Daniela, by letting people know how they could get in contact with you should they want to get their wills and powers of attorney. And, well, actually, that's something we didn't touch on, probably because it sits outside of. Whenever we're talking estate planning, inevitably we end up talking about powers of attorney. Let's talk about powers of attorney, how one of those cogs that kind of ties into estate planning without actually necessarily being part of your will per se.
Yes, so powers of attorney are just as important as a will. They are documents that operate during your lifetime, and they give authority to people that you nominate to make personal, financial and medical decisions on your behalf. The medical power of attorney, which is now called an appointment of a medical treatment decision maker.
You love how they change names
I know,
all the
time. Terminology changes every now and again.
Yeah.
So in that document, you can appoint a decision maker. That person has authority to make medical treatment decisions for you if you can't make them yourself anymore. Your decision maker can consent to medical treatment on your behalf. They can choose between different treatment options that might be available at that time. Their consent to treatment if they believed that you would refuse consent if you could. and they can withdraw treatment even if your life ends as a consequence of that decision. So it's an extraordinary power that you give to somebody, and it's really important to have. The other document is an enduring power of attorney for financial and personal matters, and in that document you give authority to a person or people who become your attorneys, and they can basically stand in your shoes as if they're you and do everything with your assets and your finances that you can do yourself, and also make personal decisions for you as well, like where you're going to live, what sorts of activities you can do, those sorts of things. So your attorney can access your bank accounts, pay your bills, invest your money, sell your house, sign your tax returns, obtain information on your behalf, lots of things.
What are the things a power of attorney can't do?
They can't change your will.
Mm-hmm.
They can update your binding death benefit nomination if you want them to, and we include that specific authority. But it basically...
So with that, this is specific to the will or to the super fund, but they can often only update it to the estate. I've seen, and I don't know if that's, again, is that at the super...
That's at the super fund
end.
level, yeah.
So I've had that where they've said they're updating it, but they can only, if they choose to do it under power of attorney, only update it to the estate to
As
essentially
opposed to
say...
nominating themselves.
Which it sort of made sense to me in that sense of their wishes were in the will when they were obviously able to put them forward.
Yeah.
So if they're going to update the beneficiary, it can only really refer back to that point.
Yeah, so we're including routinely now specific authority and powers of attorney that authorise your attorneys to call for the release of your superannuation benefits if you're terminally ill, to try and stop some death benefits taxes being paid on your death. We're also including specific provisions that authorise the attorney to renew any death benefit nominations to prevent them from lapsing. So if your fund only allows you to make a binding death benefit nomination that lapses every 3 years, you could make a nomination and then lose capacity before you can renew it, so your attorney can renew. And then also provision for the attorney to make a new binding death benefit nomination, but on limited terms. But again, that, like I said, whether the super fund accepts that authority or not is a different question.
Just with the powers of attorney, again, I won't even try with the terminology, obviously. So some people ask, when does it come into play? So, like, is it from the second I sign it, can someone else, make a change on my behalf, or do I have to be not in capacity to do so? How does that work?
So with the medical one, it only comes into force if you can't make medical treatment decisions for yourself. With the financial and personal power, you can actually choose when the person's authority commences. We overwhelmingly draft documents on the basis that the attorney's power commences immediately. That literally means immediately. It means your attorney can act the moment you sign the document. It doesn't mean that they will, but they can. My view is generally that if you trust somebody enough to appoint them, you trust that they will use that power appropriately. And if they do need to use the power, you don't really want too many hurdles in their way. You want them just to be able to use it with ease. Means it can also be used for convenience as well as necessity. So there might be lots of circumstances where you want somebody to assist you and you're still capable and competent. You might be
absent for a period of time.
You might be overseas. You might be physically incapacitated and you need someone to do something for you.
Yeah. So with the other option, it has to be enacted in terms of someone, like a medical person would have to sign off and say they're now incapable.
Yeah, that's right. Or you can elect it. The power only commences if your treating doctor has basically certified that you're not capable of managing your own affairs, or you can nominate some future date in time. So it's very flexible, that document. When you sign a power of attorney, you're not signing away your rights to continue to manage your own affairs or make your own decisions. You still continue to do that for yourself. You're just giving someone else authority to assist you if you want them to assist you or you need them to assist you. And then if you did lose capacity, that person can also step in and make decisions for you.
I think that's the fear people have, is if they set that up, that they're
get a rogue.
Britney Spears.
So you can revoke a power of attorney at any time too, whilst you're capable. I might just quickly use a minute to explain what happens if you don't have a power of attorney.
Yep.
So if you don't have a power of attorney and you lose capacity, say you have an illness or an injury and you can't make your decisions anymore, nobody has any automatic rights to make decisions for you or do things for you. So people are quite surprised to learn that you can't just make decisions for your spouse or make decisions for your parent who's had a stroke or, some accident. So if you don't appoint somebody yourself, then an interested person, whether that's, a family member or a social worker or a friend, would have to make an application to the Guardianship Tribunal at VCAT. VCAT is the Victorian Civil and Administrative Tribunal, and VCAT has the power to appoint an administrator and guardian for you who can make financial and personal decisions for you if you can't make them yourself anymore. So, one, there's a risk that the tribunal will appoint somebody that you wouldn't have appointed yourself. It could appoint an independent, like state trustees, to be your administrator.
The family challenged or something and end up going to straight state trustees, and they all lost control.
They lost all control of what happens then. So that's a risk that you could end up with someone who you wouldn't have chosen yourself managing your affairs. The other aspect of it is that it's actually very stressful for the family, because they're usually making that VCAT application at a time where there's been some trauma, some traumatic event, and then they find out that there's no power of attorney. Someone's asking for a VCAT order or a power of attorney. They have to then make that application, obtain medical reports, go to a hearing, hope to be appointed. Once they're appointed, there's ongoing reporting obligations. So it's a pretty stressful process for people.
Yeah, the time of all that to happen as well. Like, it's not an immediate thing.
It's not immediate, and it's not uncommon that we receive phone calls. You know, someone calls in and says, oh, my mum's had a stroke, she's in hospital, and someone, they're asking us for a power of attorney or a VCAT order. Can we get that power of attorney organised? And too late. Yeah, these are things you have to do when you're capable.
Yeah.
That probably brings us to sort of closing recommendations. I think that how you just worded that, it's so important to get things done while you've got the capacity to do so. In terms of your closing recommendations to anyone out there listening to this about getting their wills, powers of attorney, their estate plan in order, what do you have to say to them?
I'd say put it on your to-do list. And I know that's hard to do because we're all optimists and we all think we've got lots of time, but it has to be a priority to review. The hardest part is actually making an appointment to talk to somebody. Once you've had that initial consultation, the rest of it is easy. The drafting documents part is easy. It's really just making the time to obtain that advice in the first place. So contact us. You can go on the Harwood Andrews website, www.harwoodandrews.com.au. We've got a fairly big wills and estates team. We've got 5 lawyers. One's on maternity leave and coming back soon, and a new graduate starting very soon. We've got a couple of probate clerks, so it's a big team. All of us are able to assist you.
You're able to mention the online will service that you have?
Yes, so we've also got an online will service. There's an option if you don't want to come into our office and talk to a lawyer and have a full sort of in-depth consultation. If you've got very straightforward, simple circumstances, and we do also have an online will service. You can find the link through our website. That's a more sort of cost-effective and quicker way to get some wills and powers of attorney in place. You basically provide all of your instructions on an online form. You book in a half an hour phone or video consultation with a lawyer. The documents are still drafted by a lawyer, and you have an opportunity to get some fairly basic advice, and then we send you final documents with instructions for signing.
Perfect. And listen, we're obviously enormous advocates of what you do, and for any of those people out there listening, thinking about the complexities of sort of their financial situation, their lifestyle, if you came to us, we're obviously not solicitors. We're not going to prepare a will for you, but we're certainly going to point you in the right direction and identify the areas that maybe there's a shortfall in your circumstances. So whether it is, like as Daniela said, get it on your to-do list, go and make a time to speak to someone, whether that's a financial advisor, whether that's a estate planning solicitor, or simply do some of your own research. As you said, Daniela, get onto the Harwood Andrews website. You've got some great content on there that gives people some more explanations around wills, powers of attorney, estate planning. We really thank you for your time today. I know we could probably keep rolling for a couple of hours on topics and case studies, but we appreciate your time. Thanks for everything you've done for us and our clients over the years. And yeah, welcome to your first podcast. Well, hopefully you've enjoyed it.
Thank you. It's been a great experience, and thank you for having me. Thank you for bringing this topic to your clients' attention. We love it when clients have financial advisors, because if they don't recognise themselves that there is a gap somewhere or something needs to be reviewed, usually you're onto it before they are. So it's always good to have a second, pair of hands looking at their client's circumstances and giving them advice or a prompt or nudge about when they need to get things up to date.
Perfect. Ben, you got any closing thoughts or comments?
No, I think we come across the majority of people when you go, when we meet them for the first time and we work through our situation and you get to the end of it and you go, you almost know what they're going to say. And you go, have you got a will? And they look at you and go, just about every single one of them says, I've been meaning to do it. Yeah. But so again, it's just us reminding them, prompting them, getting them to do something and then reviewing it over time. But again, it doesn't matter whether they're 25 or 45, nearly every single person says, it's on the list to do. We just get busy. It's not that fun, but it's pretty important. So
super important.
Yeah.
Thanks again, Daniela. Thanks again, Ben. And we'll see everyone on the next episode. We hope you enjoyed today's episode. If you're keen to understand more about how financial advice could benefit you, follow us on Instagram, Facebook, and Twitter at Burke Britton FP, or Google Burke Britton Financial Partners. Check out our client reviews, testimonials, and make a time to meet one of our certified financial planners by clicking Book Now on our website. Thanks for listening.
Any information contained in this podcast is of a general nature only. No account was taken as to the objectives, financial situation, or needs of any particular person. Therefore, before making any decision, listeners should consider the appropriateness of any information with regard to their particular objective, financial situation, needs, and seek independent advice from a licensed professional specific to their circumstances.
All right, hit it.
That translates to, don't be a moron and act on what some random person says on a podcast. Take personal responsibility. Do your homework. Ask questions and speak to an actual human that knows what they're talking about before you do anything. PB Financial Solutions Proprietary Limited, trading as Burke Britton Financial Partners, are authorised representatives of AMP Financial Planning Limited, AFS, licence number 232706.